One of the things I do in my practice is act as a mediator. And people often ask me, what is mediation? What does a mediator do? They've heard the terms mediation, they've heard the terms arbitration, they've heard the terms litigation, and to the person who doesn't know what each of those things are, they may sound all very similar, but they're all very different. Litigation is where you go to court, where you have lawyers represent two sides, perhaps more than two sides of an issue, and a judge or a jury ultimately decides who wins or who loses the case. Arbitration is like a trial. It is like litigation in the sense that there is a person, an arbitrator, who makes a final decision as to who wins or who loses the case. But it's a lot more informal process and typically takes place in a lawyer's conference room instead of in a courtroom. Mediation is a voluntary process that is 100% confidential, that is designed to allow a neutral party, the mediator, to try to facilitate a compromise, try to facilitate a settlement between the parties. It's often referred to as shuttle mediation, meaning that the mediator will shuttle in between the two rooms, in between the two camps, talking to each, trying to get further compromise, and then going back to the other camp and trying to get further compromise from them until a settlement can be reached. So it's a process that will continue for as long as it appears that a settlement is available. If it becomes obvious at some point that the parties are not going to reach agreement on all the issues or even enough of the issues to make a settlement make sense, then the process will end. But so long as progress is being made, even if it's just on an issue-by-issue basis, the mediation will continue until a final settlement has been reached.